Hello and welcome. Thank you all for being here at our critical reflections on involuntary and coercive treatment under the BC Mental Health Act. My name's Sally Thorne, and I'm a professor here at the School of Nursing, and I have the privilege of being the moderator for today. These nursing dialogues sessions are times when we can listen to people's perspective on complex issues and have lots of time for respectful debate, questions, conversation between the panelists, conversations between you and the panelists, and see where the conversation goes. So be prepared to participate. I want to start by just acknowledging we're privileged here to be speaking today and connecting today on the traditional unceded land of the Musqueam people. And that really does bring with it that honor of being able to reflect on the history of how knowledge got exchanged in cultures that have been here since time immemorial, and the idea of telling stories, and the idea of listening respectfully, and the idea of engaging in complex ideas. And I think if we take that with us, we can really ensure that we have good and thoughtful conversation today. I'd like to welcome any of you who haven't been here before to the UBC School of Nursing. It is not a beautiful building. We're kind of crammed into this third floor of the hospital building, but we have high hopes, and we will indeed eventually emerge into our own space. So we've been occupying this interesting land for far too long, since 1980. It was temporary space at that time. A couple of notes to begin. If you're looking for restrooms, the main ones are down this hall. They're connected with where the elevators are. They're all close to elevators. There are male and female ones down this way. If you are looking for gender neutral ones, you have to go in both directions and also turn a corner. Think of this as a great big square, big concrete square, and we're at one corner of it. The others are closer to the other end, but don't hesitate to ask, because everybody who lives and works in this building is very used to being asked for directions. So hopefully that's helpful. There is food at the back, and please feel free to just jump up and help yourself. We can be informal. We won't take a specific break for food, so get up and help yourselves. I know some of you may have to leave. There may be other people who find their way here at a later point, and feel free to make them welcome and just point them in the direction of the food so everybody can feel comfortable. The overall plan, one other thing before I talk about the speakers, is that we do have a number of people who are here virtually today. We had indicated, as you probably know, and from our past dialogue sessions, that we would record this and have this available for people. It's an audio cast with the slides that they will have access to, and so if you have friends that would have liked to be here and weren't able, that'll be posted shortly. But because of the current situation we're in the world at the moment, a few people had phoned up during this week and said, could we also make it live while it's going on? So we do have a few people online. And should they ask questions, Marilee will send them along to us. So I'd like to just introduce our speakers, and for the first part of the session, we'll allow each of them to tell you a little bit about what their interest in this topic is and their expertise in this topic is. Each of them will talk for 10 minutes or somewhere in that vicinity, so we'll be able to hear their perspective. We'll then engage in some discussion back and forth if that's useful, and then open it up to the group. And I really invite you to take part in the debate. Feel free to ask any and all questions, and also to express opinions. I think that's absolutely fair game as well. So our speakers, as you know, are Laura Johnson, Legal Director from Health Justice. She's going to talk about what the BC law currently is around coercive care. Maya Kolar, who is a clinical nurse specialist in the emergency department at St. Paul's Hospital at Providence Healthcare, and she is a recent MSN grad that we're all very proud of. Recent prize-winning MSN grad that we're all very proud of. And her perspective today is going to be insights from a critical discourse analysis of BC's Mental Health Act. And Iva Chung from Mental Health, who's a Mental Health Act rights advice researcher from Simon Fraser University, is going to talk to us about helping patients understand their rights under the BC Mental Health Act. Finally, Emily Jenkins, who's an assistant professor and a colleague of mine here at the UBC School of Nursing, is going to talk about the implications of the Mental Health Act and coercion on nurses in practice and also students entering those settings. So that's the general background that we're going to get to get us into a lively discussion. I'm going to ask the speakers if they don't mind to come here over here because the mic will be here. We will be able to pick up the panel discussion, but I do invite people as they're talking to kind of be aware that there are people online and in the future looking at this, so we'll try and make sure that your words can be heard. Over to you, Laura.
Thanks. Yeah. Can I also just get a show of hands, like students, practitioners, faculty, anyone else I'm missing out on? Okay, great. Just trying to get a sense of who's in the audience. I was anticipating more of a nursing student audience. So yeah, what can I tell you about myself? Because we were doing a little intro. So for about 6 or 7 years, I've been a mental health lawyer in the province. So I have litigated on behalf of clients who have been receiving coercive care. And by that term, I mean some sort of intervention in their life, whether that's a deprivation of their freedom or their ability to make their own decisions, impacting their own care or finances, etc., under one of several statutes. The Mental Health Act, of course, being the most commonly used, but by no means the only. While I was doing that litigation, I was also wearing many hats, doing research off the side of my desk, doing some policy work, doing some systemic advocacy and communications work. And now I've transitioned into this new role. I'm part of a group that's founding a new nonprofit in the province that's going to be just focused on how to integrate best practices and human rights principles into our coercive care laws, policies, and practices. And that group is going to be called Health Justice. We don't have a logo yet, but it's literally being worked on as we speak. So I usually start my talks by addressing sort of 3 common myths that I encounter when we talk about coercive care in this province. And these are sort of like general cultural understandings that I bump up against. So one is the idea that, you know, if someone's heard about civil detention or mental health detention, their understanding of it is, oh yeah, that's that thing under the Mental Health Act, and that's the law that governs that. And while that's not untrue, that's not the full picture. And if you have a mental illness and you're a danger to yourself or others, then you can be detained under that act. The second sort of idea I encounter a lot is that there's a really high threshold to detain someone under the Mental Health Act. And so very few people get detained. And there's lots of people with mental illness who don't get detained under this act. And that generally speaking, while, you know, it might not be ideal to detain someone and involuntarily treat them or impose other interventions on them against their will, that's sort of what the price we have to pay, because there's a conflict or a tension between preserving someone's rights and making sure that they get the treatment that they need. I think all of these things are untrue. And during my 10 minutes today, I'm going to be largely talking about those 3 ideas. Is there a camera as well? No. I have a movement habit. I can't stand still, but as long as I'm close enough to the mic. So just in terms of that first idea that, oh, there's this one statute that addresses civil mental health detention in this province, I actually just want to introduce you guys to a few other laws under which people can be detained. Certainly the Mental Health Act authorizes detention at any age. There's no floor or ceiling there. But then there is also a statute called the Adult Guardianship Act, which only applies to those 19 or older. And there's a great deal of controversy about whether or not this statute permits detention and involuntary interventions. Some health authorities have not used this statute. Some health authorities have. There was a court case last year that found that at least one of the people who's been detained under this act was detained illegally, and that violated her constitutional rights and should not have happened. So that's still a big question, but there are some health authorities in this province that are relying on this act to detain. And then the Healthcare Consent Care Facility Admission Act recently in November proclaimed some really old zombie legislation from 1993. It's been sitting unenacted on the books since then. And this will now permit admission to a care facility without the individual's consent or substitute consent. So in essence, a state power of detention. Unfortunately, this legislation, because it's so old and has been amended and pieced together over the years, is pretty poorly written, and it's unclear what age category this will apply to. Sometimes the statute says adults, pretty clear it's 19 or older, and sometimes it says persons, which implies there's a difference. But it's anticipated that this will disproportionately impact seniors. And then some of you might have also heard about the bill that's been tabled for first reading, I think now 3 times in this province, called the Safe Care Act. It's a private member's bill, it's not a government bill, and it's never made it past first reading, but there's been a lot of interest publicly in the media, so I thought I would address it. The idea behind that statute would be that you could detain a 12 to 19-year-old youth who is likely to suffer from commercial sexual exploitation or serious substance use issues. And there's a lot of limitations around the use of that, but something to keep an eye on that might be coming. And then there's this idea of dangerousness, right? That if you're at risk of harm to yourself or others, you can be detained under the Mental Health Act. Certainly that is the standard in most places in the Western world. And that was our standard until the 1990s. But a round of amendments in 1998 expanded that quite a bit. So I've just put as a refresher, I'm sure a lot of people in the audience know our Mental Health Act criteria for detention. And I don't have time to get into it. I actually teach a 13-week course on this at the law school. So feel free to drop by if you want an in-depth on that one. But the critical expansion here was, of course, you could be detained if you need to be detained for the protection of yourself or others, but also now you can be detained to prevent your substantial mental or physical deterioration. So the idea that the detention would be necessary, even though you're at no risk of harm to yourself or others, because you might be in the future. And then this idea that Mental Health Act detention is very rare. And I think, where this comes from is a lot of us seeing largely housing-based crisis of individuals on the street, which seems to be growing and everyone's incredibly alarmed and worried about, understandably so. And so there's this impression of, there's been calls in the media of, should we think about institutionalizing people again? Is that something we should go back to? The reality is we never stopped institutionalizing people in this province. In fact, there are more people institutionalized now than there ever were at the height of large-scale institutions like Woodlands, Trunk Hill, and Riverview being open. So I have on this slide here data for voluntary and involuntary mental health hospitalizations in BC. The teal or green line right here is voluntary. And as you can see, that remained fairly stagnant. In fact, it's gone down a little bit. And the blue line is the involuntary admission. So those have skyrocketed over the last decade or so, now to the point where it's over 20,000 involuntary admissions every year. So we can see from these numbers that when our mental health system is interacting with people, it is primarily in a coercive way, in a way that approaches people from a place of removing their decision-making rights, rather than in a voluntary way that engages them where they're at. So the ombudsperson broke down some of these numbers and said with this increase in involuntary admissions, there's actually been a 71% increase in detentions over that 10-year period, and that the stagnation of voluntary admissions actually means that voluntary treatment has decreased per capita. There's been a 15% population increase, and so a failure to see any rise in the voluntary admission actually created a decrease in voluntary admissions per capita. And the Ministry of Mental Health and Addictions recently announced that BC has the highest rate of hospitalization in the country for mental illness and substance use. I have lots of thoughts and theories about why. Maybe we can get into that later. So there's been some very well documented issues with non-compliance with the law itself that is on the books. So I conducted some research that was published in 2017, Operating in Darkness, that documented widespread rights violations on many different indicia for detainees. One example I've pulled out here, which we'll get into a little bit later in terms of what the trickle-down effect has been, is documentation of healthcare providers offering inducements, making threats or exerting pressure or actively interfering with detainees' ability to access review panels, which is a tribunal that is independent from the facility and the detainee who adjudicates whether or not detention can continue. And then the Ombudsperson's report published last year documented lots and lots of compliance issues. I'm sure you guys have heard about it. Just as a highlight, they found only 28% of patient files included the initial set of regulatory forms required by law. It's like 6 pieces of paper. And the vast majority were missing, and that doesn't include whether or not they were properly completed, just whether or not they were physically on the patient's chart. They found that the Form 5, which is supposed to document what treatment was given to the patient, was completed in less than 1% of the cases in an adequate way, and that largely they were rubber stamped or to record in a way that was to be so vague as to be meaningless. And then finally, that the notification of legal rights was completely absent in 51% of the files, and it wasn't completed or wasn't completed promptly in many more files than that. So the vast majority of detainees are not getting rights notifications completed, and that's, I'm sure, something Iva's going to talk about a little bit more because she drilled down on that form, the Form 13. And what does that non-compliance mean? So I've put up here the Mental Health Review Board's applications and hearing totals. They put them in reverse chronology, which I try not to be cynical about, but you need to actually read this from right to left to be able to understand it. So what you can see here is that while the detained population has increased exponentially, which just to remain stable, the number of independent reviews would have had to have increased, there's actually been a decrease in the number of detainees who are requesting review panels, down from 2,200 in the 2016-17 year down to 2,092 in the most recent fiscal year. And then the number of actual hearings that detainees are able to attend has also gone down. There's been a bit of a blip, 832, 878, 820. Remarkably, that means a tiny fraction of detainees are getting access to independent review. About 10% ask for review, and about 4% get access to the review. What's interesting about this is, of course, a lot of people are released before they can have a chance to ask for review if they're decertified, and that explains the orange bar here, the 352, 372, 408. But the blue is the number of detainees who are still certified but just cancel their review panel, and that is a much more substantial number in the 7 or 8 or 900s. And it's those numbers that the board is particularly concerned about. Why would such an alarming number of detainees be asking for a panel and then canceling it afterwards? There's also very unfortunate documentation that even if we were complying with the existing law, our existing law in this province is very bad. This is beyond question. The United Nations Special Rapporteur on the Rights of Persons with Disabilities recently inspected Canada in its entirety on every compliance with the Convention on the Rights of Persons with Disabilities. And from coast to coast, in every area of disability law, pointed out one statute, the BC Mental Health Act, as being shockingly non-compliant with the rights of persons with disabilities. So we're sort of developing this great international reputation for how very bad our Mental Health Act is. And of course, I don't have time to get into it, but there is a lot of case law in other provinces that demonstrate that if detainees were able to access courts, if there was sufficient legal aid, if cases could get through, many provisions of our mental health would be struck down as unconstitutional. Just a couple examples. In Alberta, they said that the absence of an independent rights advisor meeting with every single detainee upon detention was a constitutional violation. And just to put that in perspective, in Alberta, they actually have independent rights advisors that a detainee can ask to meet with. In BC, we don't even have that service. There's no legal aid funding at all for someone to access independent rights advice when they're detained, which is why they end up relying on facility staff. And then there's lots of documentation that overrides on someone's wishes and preferences and values around their healthcare decision-making is unconstitutional. And that, for example, the solitary confinement case, which I will just say with an asterisk is still winding its way through the courts, it's under appeal, but found that individuals can't be put in solitary confinement in prisons if they have mental health issues because the isolation and sensory deprivation caused or exacerbated mental health symptoms to such a degree that it was unconstitutional. And of course, we solitarily confine individuals in psychiatric institutions, all of whom hopefully have a mental health problem regularly in BC. I'm probably running out of time, hey? I'm gonna skip my fabulous chart I've done here just to give us a brief overview of rights that are covered in different statutes and not covered in other ones. largely to demonstrate the idea that, first of all, this is very scattered. There's very little coherent analysis about which detained population gets which rights, and that by far the Mental Health Act is one of the worst performing. This is the Safe Care Act. So essentially youth ages 12 to 19 would have rights like the right to same-sex clothing removal, the right to make their own healthcare decisions, while an adult detained under the Mental Health Act wouldn't. And then, of course, the issue that our existing law isn't based in evidence. I've pulled out one small example here, the goal of addressing the revolving door pattern of admission, stabilization, discharge, discontinuation of treatment, and then a change in status that causes readmission again. The hypothesis behind mandatory community treatment orders was, well, maybe if we keep someone in community under the compulsion of requiring to comply with treatment, we can stop that cycle of readmission to hospital. It's a great hypothesis. We've used it very heavily in BC. I've put up here a chart of our extended leave rates, which tripled in a few years and have gone up since 2015-16. Anyone know what the issue is with compulsory community-based treatment hypotheses? It doesn't work. It's a great theory, but there's been independent meta-analysis reviews that demonstrate that actually compulsory community-based treatment has no impact whatsoever on readmission rates. And actually, there's documented counter-therapeutic effects. So what therapy someone would be getting from that treatment is reduced by the coercion that they're experiencing, which impacts ability to access effective recovery. It impacts their ability to access healthcare services in the future. It impacts their relationships with their healthcare providers. So I have lots of thoughts on patient-centered coercive care, but I hope that's something that Maya and the others will be talking about. It's something I do a whole day-long workshop about with nurses and with physicians. So I'm happy to continue the discussion, but I should probably end about there.
Ooh, short. we're tantalized by those slides. We're going to hopefully have time to research them as well. Yeah.
Thank you. Yeah. Hi, everyone. My name is Maya. I am currently a clinical nurse specialist in the ED at St. Paul's Hospital. I finished my thesis here under the MSN about a year ago now, I think. My background is also an RPN. I trained at Douglas College initially, and most of my experience actually relates to the Downtown East Side doing community outreach, nursing, mostly related to wound care and a bit of mental health team work. So that's just a bit of a background. So before I delve into my slides, the reason why I chose to approach the Mental Health Act through critical discourse analysis was because I was curious to see how legislation actually impacts practice and how language actually forms that practice and influences nursing practice, but also how certain people are positioned in positions of power to enact legislation and what that means for patients. So as noted, I analyzed the Mental Health Act as well as the Guide to the Mental Health Act. For those of you who are not aware, the Guide to the Mental Health Act was a document created by the ministry in 2005 to help translate the legislation for service users, patients, and their families. I'm sure I was going to chat about that a bit. So the reason why the Guide to the Mental Health Act was created is because the legislation itself is really hard to understand and apply in practice. Even I find it confusing quite often, even though I've done my thesis on it. Yeah. So with a discourse analysis, it's important to look at the social historical reasoning for the issue. And unfortunately, we don't have enough time to look at the whole history of involuntary treatment. But I will look at how the Mental Health Act was created. So the Mental Health Act initially was created during the process of deinstitutionalization, meaning moving people from institutional care settings into the community. And this was around 1960s. So during the 1960s as well, all the way to current, the DSM increased in prominence as well as biomedical discourses related to psychiatric treatment. So this is just kind of a fancy way of saying that the Mental Health Act is quite influenced by the DSM and biomedical discourses, meaning that we mostly rely on pharmaceutical treatment and individual-based treatment methodologies versus more of the social aspects of care. So similar to what Laura noted, the Mental Health Act, since its creation in 1964, has been changed, however, not necessarily for the better. So since 1964, there has been an overall broadening of involuntary committal criteria, removal of healthcare practitioner liability and accountability, and also reduce procedural checks to ensure that we're actually applying it correctly in practice. So ultimately, all these changes have made it easier to apply involuntary treatment without actually necessarily being accountable for its practices. And another important note is the last significant amendments to the Mental Health Act occurred in 1998, with the most recent, which were minor changes, occurred in 2018. So a very old piece of legislation, at least 20 years old. And finally, in terms of current standing, involuntary treatment is the primary approach of care, similar to what Laura noted. So about 20,000 people a year right now are being voluntarily detained and treated across British Columbia. So for those of you who have not worked with the Mental Health Act, here's an example of a form that I analyzed, Form 4, one of the most famous forms for involuntary treatment. So that's just how they are structured. So the most prominent findings of the discourse analysis included the discourse of protection, the positionality of those receiving protection, also known as patients, and the positionality of those enacting the protection through legislation. So the discourse of protection within these texts was applied to patients, their rights, healthcare practitioner liability, as well as the safety of the public. So protection is generally applied to people with identified mental disorders. This is archaic terminology that the Mental Health Act uses. And unfortunately, the Mental Health Act does not actually define protection and what it means. Actually, it's the guide to the Mental Health Act that points to a general definition from a court case. So it's a roundabout way of defining what protection is, and the Guide to the Mental Health Act states need for protection goes beyond physical dangerousness and includes threats, violence, delusions, deteriorating health, dropping out of school, grossly unsanitary living conditions, suicidal ideas and behaviors, and the list goes on for a little bit. So with that list of behaviors, you can see that almost any behavior deemed a risk or mental health concern can be legitimizing protection under the involuntary treatment, depending on a practitioner's understanding and view of a behavior. So I'm not sure if in practice you've seen, but the standard for admission for involuntary care is very different depending on for example, physician's view. If you work in the downtown east side at St. Paul's, it's generally understood that the bar is actually quite higher, apparently, in terms of involuntary admission, whereas more remote areas might be lower. But that's definitely to be debated. And in terms of application, protection apparently is identified as being applied through seclusion, restraint, removal of personal clothing, as well as using locked units. So in terms of positioning of patients, patients were generally positioned within these texts to be risk-laden objects that were either too vulnerable or too dangerous to care for themselves and therefore in need of involuntary treatment through a designated facility. So the presence of a mental disorder within the Mental Health Act would presume a patient as incapable of actually providing consent or even revoking consent to psychiatric treatment. So in general, there's no consent process within the Mental Health Act, even though technically Form 5 is supposed to be that, you actually do not need consent from somebody. This is also known as the deemed consent model in the Mental Health Act. And also to note, sidebar, we are the only jurisdiction across Canada that uses the deemed consent model. Let's see. In terms of who implements protection, so there's three main actors within the guide and the act, includes physicians, police officers, and nurses. So physicians are positioned with the majority of power in order to enact mental health treatment involuntarily. They decide the course and type of treatment, the length of detention, as well as the length of treatment on extended leave as well. Police officers are positioned to promote protection in the community by apprehending and detaining people who they might perceive as being unsafe or abnormal, or depending on the behavior. And then nurses, finally, are actually the ones to enforce directly involuntary treatment. For example, applying the physician's orders, physically applying the restraints, engaging with seclusion room orders, as well as documenting whether somebody is being compliant with care. I'm not a fan of the term compliance, but that's generally what's accepted in healthcare. One interesting finding of the discourse analysis was the level of invisibility that nurses had throughout these texts. So nurses actually apply the majority of involuntary treatment, being the front line. However, in being invisible, it actually acts as a function of power in that obscures nurses' role of applying involuntary treatment. So I found that really interesting. So implications. So in terms of implications, since patients are identified and seen within these texts as mentally incapable, including as incapable of providing consent to any process, healthcare practitioners are positioned to act in the best interest. However, this idea of best interest is also an issue in that in not asking somebody what their interests are or being collaborative with them, we actually just paternalistically displace what their actual or presumed views are. So we act on behalf of them without necessarily engaging with them and their needs. And such assumptions of incapacity actually help to permit and justify the removal of decision-making power and collaboration on treatment plans for patients. In terms of interest served, there's an overall lack of consultative processes and collaboration. And unfortunately, the Act and Guide prioritize behavioral control, meaning individual-based interventions versus more of a structural change approach and social change approach. In terms of nursing practice, what Emily will speak more to is that unfortunately, nurses are positioned in very contradictory ways in practice. So not only between professional obligations under the Act, but also between their code of ethics. So as a nurse, you're asked to implement, for example, engaging in coercive treatment practices, but yet at the same time, you're being told from your code of ethics to be socially just and ethical in your approach and compassionate. So that's quite a lot of dissonance. Nurses also are positioned to work against aspects of the Charter of Rights and Freedoms, such as the right to liberty and protection against arbitrary detention. And also they have to engage in competing models of care, such as the biomedical and psychiatric orientations, which are highly individual, versus more of the biopsychosocial models that are generally taught and accepted in nursing programs and schools. So this all points to how the system and structure is actually oriented more to a biomedical and psychiatric approach, which focuses on individuals versus the structural issues at hand. So similar to what I was saying, broader impacts. So in terms of my findings, I found that the Mental Health Act was actually used as a tool to deal with systemic issues on an individual basis. So rather than dealing with the issues of, for example, poverty being the #1 determinant of mental health issues, we've seen the Mental Health Act used as a tool in order to actually engage with that issue only on a crisis basis. So it's not that we're necessarily helping people through their mental health issue, rather we are detaining and then usually releasing them in the same environment that likely caused mental health symptoms to begin with. And also, involuntary psychiatric treatment commonly disadvantages those who are already experiencing social and economic marginalization. So conclusions, broadly, the Act and Guide are heavily influenced by the social and historical context from which they arose. And the manner in which the Act and Guide construct protection and position patients, as well as those enacting protection, highlights how discourse operates to support practice in very specific ways. So for example, limited collaboration, limited accountability, and minimal oversight of these processes has all affected how mental health treatment is provided. In terms of recommendations, I suggest completely restructuring the Mental Health Act, as I'm sure most of us here would. And in terms of the Class BC report and Ombudsperson's report, I highly recommend reading those two reports because the recommendations are pretty spot on. So for example, Class BC's report, the one written by Laura, analyzing what a consent model would mean for British Columbia, and rather than relying on deemed consent models, and also looking at assessment of a person's capacity to consent and increased oversight and accountability of involuntary treatment processes. And finally, in terms of discourses, I would suggest applying the discourse of equity more into mental health and psychiatric settings. For example, equity-oriented care, which includes trauma and violence-informed care, gender-affirming care, culturally safe care, and harm reduction, to be woven through legislation such as the Mental Health Act in order to actually provide a safe and compassionate experience for somebody who actually needs involuntary treatment versus more of this like negative and traumatic experience that's currently unfolding. And I think that's about time. So pointing to the same resources, two of which Laura's the first one and I was the second one, and then that's the Ombudsperson's report. Yeah, it's kind of a summary.
All right, I'm up. Okay, so my name is Iva Chung. I finished my PhD in 2019 at Simon Fraser University's Faculty of Health Sciences, and I studied how to help patients. I am going to use the term patients. I understand that's not everybody's preference, but that's the term that the legislation uses, so that's the term I'll be using today as well. My project was centered on helping patients understand their rights under the Mental Health Act, and they do lose some of their rights when they're certified. But they don't lose all of their rights. In fact, as Laura mentioned, they do have the right to challenge their certification by asking for a review panel hearing. They have the right to ask for a second medical opinion on their treatment. And they're supposed to be told about these kinds of rights when they're first admitted. But what prompted my research was that a 2011 survey that was commissioned by the Ministry of Health found that 43% of people who responded to the question, were your rights under the Mental Health Act explained in a way you could understand? They said no. So this is a problem not just from a fundamental human rights point of view, but also because giving people information can itself be therapeutic. I looked at this issue through a lens known as therapeutic jurisprudence. That's a field of study that sees structures of the law and agents of the law as having therapeutic or anti-therapeutic effects. And what that literature consistently shows is that giving patients a sense of procedural justice by telling them what their rights are and by helping them exercise their rights can reduce their feelings of coercion, it can reduce their feelings of learned helplessness, and it can actively engage them in their own recovery and care. In contrast, not having information can increase anxiety and also breed mistrust. So to illustrate that, I have a quote here from one of my interviewees, Deborah, it's a pseudonym, went into a hospital seeking voluntary care. She was certified. They did not tell her she was certified. She doesn't remember receiving her rights information. And she said, I don't think a single person talked to me like I was a human being in the entire stay. The worst thing about going in as voluntary and having such a horrible experience is I don't trust that system. I don't want to go anywhere near the hospital again. Okay. One of my other interviewees, Ethan, was more concerned about the boundaries of the law. What can the hospital do to me under this legislation? And you can imagine how terrifying that would be to be in an unfamiliar location and situation and knowing that you're detained under a piece of legislation, you don't actually know what the legislation says the hospital can and cannot do to involuntary patients. So he said it kind of felt like they could have done anything and told me, oh yeah, we can do this under the Mental Health Act. And I wouldn't have known. I wouldn't have known even if I could have fought it or I should have. It was just, I had no idea what was potentially going to happen when I got committed. So what I'm hoping to illustrate is that giving people rights information isn't just a procedural safeguard. It can actually be a really important part of the patient's therapy. So to find out why that number of 43% was so high, I started off by doing a few key informant interviews with people in the mental health system, and asked them about their speculation on the reason so many people were reporting that they were not being told their rights in a way they could understand. And what they told me sort of boiled down to these three main reasons. The first is that the clinicians in BC who are tasked with giving people rights information may not be doing so consistently. And the ombudsperson's report really showed that that is true, that they're not giving consistent rights information. A second possible reason is that when people are first certified, they might not be in a state of mind to be absorbing information or to remember that they've been told certain information. And the third possibility is that the tool that's being used to give people rights information, right now it's the statutory Form 13, might not be a very good tool for communication. So this is what it looks like. I don't expect you to read that. I just wanted you to see, how bureaucratic it looks. Clinicians, usually nurses, sometimes social workers, occupational therapists, or physicians will read that first page to somebody who's first certified. Crucially, this form had never been user tested with its target audience. So it was never shown to people who would be reading it to see if it was effective at communicating this information. So that's one of the first things I did. I talked to 18 participants, showed them the form, asked them to tell me, to think aloud as they read through it, tell me what they liked about it, what they didn't like about it, and whether it met their information needs. And what they told me was that it did not. Okay, so they objected to a few things on the form. They objected to some of the language. They found it a little bit stigmatizing. So one of my participants said, you are a person with a mental disorder. That wording really doesn't sit right with me. The form also has the term habeas corpus on it. And if you've never taken law, then that probably doesn't mean a whole hell of a lot to you. Okay. And the participants also objected to the signature line on the form because all it says is patient signature. The function of that line is for clinicians to have the patient signed to acknowledge that they've been told about their rights. But what the patient sees is a document that says rights on it and a signature line at the bottom. They don't know if they're relinquishing some of their rights. They don't know if they're entering into an agreement that they don't entirely understand. And that's not made clear here by the signature line. So essentially what the participants told me was that they wanted information in more than one format. Just having this one written document, even if the first page was read out loud to them, wasn't enough. They found the legal language and format quite intimidating. In fact, they thought that this document didn't show a genuine interest in having them understand their rights. They thought it looked more bureaucratic and really an administrative necessity for clinicians to cover their own liabilities. They wanted more empowering, friendly design and language. They wanted some color in there, something engaging to read, and they wanted more help exercising their rights. So the form says, you have the right to contact a lawyer. And most of the participants would say, well, how do I do that? Because the form doesn't actually give them any additional help to contact the lawyer to exercise their rights. So I took all of this feedback and started working together with a patient-oriented research team consisting of 2 patient partners and a clinical nurse educator. And this is Andrew, one of our patient partners. And our goal was to co-create a brand new suite of communication tools, including a pamphlet, a card, a video, and posters. And this suite of communication tools really was co-created by patient partners. They wrote the first draft. This was written by patients for patients. Okay. And we didn't want to replicate the mistake that the government had made in not user testing. So we took these tools and we did 3 rounds of user testing with 16 participants in total and revised the suite every time based on that feedback. And what we ended up with was a pamphlet. I have some examples here if you'd like to look at them. We also have a wallet card. We have a large poster with the basic rights that you'll find on the card as well, and a smaller poster with just the very, very basic rights that then refers people to the pamphlet for more information. We also have a video that's available on YouTube that explains rights in an animated style. Okay. So what we found in our user testing was that participants vastly preferred these new materials compared with Form 13. When we asked them after the session to name their rights that they learned from these materials, most of them could name most of their rights. What they told us was that they didn't want these materials to replace conversation with clinicians. So they didn't want to just be sat down in front of a computer, shown a video, and have that be the end of that interaction. What they wanted was a safe environment to be talking about rights without fear of punishment or retribution. Because some people felt that if they even brought up the issue of rights, that they would be held longer, they would be seen as a troublemaker or a problem. And so they wanted an environment where they could actually feel safe speaking about their rights to their care team. Okay, so this is a quote from one of my interviewees, Yevon. He said, even if people have access to this kind of information, if the staff don't see it as okay to talk about, then I mean, it's almost like palpable. People aren't going to talk about it. Or if they are going to talk about it, it's going to be very confrontational. So this shows the importance of not just having these materials, but also having them implemented in a way that is patient-centered and that respects their desire to have an open conversation about their rights. So I am happy to discuss any part of this project in more detail, but I'm aware of time, so I will just let you know that all of these materials are available on the bcmentalhealthrights.ca website. And finally, I'd like to thank my amazing patient-oriented research team, my team of supervisors, and all of the funders who make this research possible.
All right. So thank you all for the presentations you've given so far. I have to say my expertise in this area pale in comparison to the work that you're doing, and I so appreciate the work that you're doing. I'm hoping that my contribution to today's discussion can be to bring a bit more insight into the experiences that nurses have in terms of working in these contexts and enacting the Mental Health Act. So my brief presentation is going to include a bit of a background to contextualize my interest in this area. I'm going to talk a bit about nurses' experiences with the Mental Health Act and end with some thoughts that I have around hope that we are making some progress in improving the Mental Health Act for our patients and the clinicians using it. So I wanted to start off by giving a bit of a shout out to Ken McDonald, clinical nurse specialist for mental health and substance use in Fraser Health Authority, and also adjunct faculty here in the School of Nursing, as well as Damon Deline here, clinical nurse educator, mental health and substance use in Northern Health Authority, both of whom jumped right onto a call to help bring me up to speed in terms of the Mental Health Act in the clinical context as it relates to nursing. And so I appreciate the insights that they've given me that have informed the talk I'm going to give today, as well as the work that they're doing in leading change in this area. So it feels a little strange to be here talking about the Mental Health Act because the majority of my program of research focuses much more upstream, incorporating concepts such as mental health promotion and prevention, in essence trying to mitigate the use of the Mental Health Act and related coercive treatments. But the roots of this orientation really stem from my experiences working in acute psychiatry as a nurse and witnessing the impact that coercive treatment under the Mental Health Act and other forced treatments had on the clients that I was working with. There's also a lot of confusion in these clinical contexts in terms of how the Mental Health Act should be applied. And so just wanted to say, Iva, I so appreciate the work that you're doing in terms of helping to educate nurses so that they can provide further education to the clients that they're working with. And so I was really challenged by the ways that I saw our clients impacted by this form of treatment and was questioning the ethics and the therapeutic value of determining for others the care that would be provided for them, or at least the ways that this legislation was being applied in practice. So my clinical colleagues have nicely outlined for me what they would identify as three of the key issues that nurses face in using the Mental Health Act in practice. The first being profound knowledge gaps. You know, it's been over a decade since I was in clinical practice. These remain in terms of the legal process for applying the Mental Health Act. Number two is what they termed antiquated policies that in essence disempower or remove opportunities for nurses to have meaningful decision making in terms of the application of the Mental Health Act. And we heard a bit about that in terms of how it's enforced and applied in treatment by Maya, and where it's predominantly physician instituted. And then three, a profound reluctance on behalf of healthcare providers to engage or critically challenge each other around the inappropriate application of the Mental Health Act. And so clearly a long way still to go. My exposure to these ideas and to thinking about coercion continues in my role as faculty here in the School of Nursing, where it comes up in the context of teaching the undergrad mental health course to students and working with them as they enter clinical practice contexts and are faced with this legislation and the tensions that arise in these settings, as well as with graduate students who have chosen to focus on these topics and bring their clinical expertise and observations to this work. So a few years back, I was working with a student, Ali Sleman, who's now a doctoral student here in the School of Nursing, who was interested in doing a directed reading study with me and delving further into these ideas around coercion and to uncover some of the roots and do some theorizing around how these practices are enacted and why, particularly tied to nursing practice. And this resulted in a 2017 paper. If you're interested in this topic and you haven't read this yet, I would highly encourage you to do so. She's done some fantastic thinking around why these tensions have arisen and the narrative of risk and risk management that is so prominent in our mental health contexts. She also outlines the historical use of confinement within mental health settings and has linked this to the contemporary nursing values of safety and risk management. She notes that practices that accord with this value are legitimized and perpetuated through the safety discourse, despite evidence refuting their efficacy and patient perspectives demonstrating harm. And so I think this is one of the greatest barriers that we face in trying to create changes to these practices, this idea that mental health contexts are inherently risky, that patients are inherently violent, and that we require this form of legislation in order to provide care. Indeed, if you do a search of the literature around nurses' experiences with the Mental Health Act, you will get an abundance of articles on risk and safety, but it is mixed as well. In some work, nurses talk about how it's considered part of their practice. It is a duty. It is necessary in ensuring safety on a unit, while others talk about the deeply ethical tensions that arise for them in applying the Mental Health Act and other coercive practices to care. In a qualitative study that I came across, this quote was provided: "It's part of the job, but it spoils the job." And it's this spoiling of the job that really resonated with my experiences in practice, and I know so many others. So just to fully make sure that I've characterized, or that I am characterizing the experiences of nursing, or nurses in the context of working with the Mental Health Act, many describe feelings of anguish and guilt. This is largely tied to situations where they feel that they could have done more to prevent the application of coercive practices or forced treatments such as seclusion and restraint that are so damaging to patients. Some described hating the practice, which I can understand. Some described anger towards the patient. This often came up in situations where nurses felt that the patient had, in their actions, produced safety concerns that required the use of these interventions. Some described fear, and again, this was tied heavily to this narrative that I mentioned Ali was discussing around safety and risk management. Many described trauma, and unfortunately, these weren't just singular experiences of trauma. For many, these manifest in more clinical experiences such as post-traumatic stress disorder under conditions where they're repeatedly having to apply these types of interventions. And perhaps most concerning was that there were nurses who described having no emotional response to the application of these. And I'm not really sure what to make of that. So I've hypothesized that perhaps in these settings where there is this inherent disconnect between people's rights and the care that we're providing, that for some there's some level of dissociation that has to occur in order to protect them to cope within these environments, because I don't know what else to make of that. And so I just want to make it clear that in speaking about this issue in this way, I'm not trying to in any way minimize the risk or the safety concerns that people have in practice, but rather to encourage us to take opportunities such as this to engage in more critical reflection and to nuance the issue, and to try to break apart unit cultures that maintain practices despite knowing that they are harmful and despite when there might be better options available. So to end off my presentation on a note of hope, I am hopeful about the increased recognition that is happening at a provincial level and a national and international level around the Mental Health Act and BC's Mental Health Act in particular, as well as the health authority and unit level interventions that are happening. I'm so appreciative for the work that you're doing, Laura, Maya, and Iva, in terms of leading change on the ground that is resulting in systems level changes, and I'm hopeful that we will be moving in a better direction moving forward, while recognizing that there's a long way to go. And so very much looking forward to engaging in some dialogue and engaging with you who are here today about where we go from here and talking more about questions that may have arisen. So thank you.
Maybe we can just move that mic a little closer to the panel table if that's possible, ladies and gentlemen. Before we open it up to our audience, is there anything anyone in the panel wants to just jump in and clarify or say more up before we move forward? We'll just have you respond from here.
I don't know if there's going to be any debate. I don't think anyone said anything. Any of us would disagree. Let's try.
Yes. Anyone who has a quick debating issue.
Yeah, I have a question because while I appreciate completely all the perspectives, some of you may know that I also I'm coming to this topic from a historical perspective. And one of you, and I think it was you, Maya, who said that the historical sort of perspective centers a lot on the language of protection. Mm-hmm. And I was just wondering, because I honestly think that that is actually true. It has come into some historical interviews that I've done, that people tend, even in the broader culture, not necessarily nurses, but to sort of think that this legislation is sort of grounded in ideas of protection and hence positive, no matter the context. And so I was wondering whether you want to speak to it, to what then sort of the discourse of human rights does it do something to unsettle or reinforce or completely offer something different? How do you see those two still, I think, culturally quite forceful ways to think about mental health legislation and practice existing both?
Just to interject, if you do have a longer question, we may need in the future to get together a little closer. Not to give a speech, but yeah. But if you could you just quickly summarize the question before you begin to answer, if you don't mind?
Well, my brain goes everywhere, but my understanding of the question is how this idea of protection may or may not be in dissonance with the idea of human rights. Is that right? So for me, the first thing that came up when you were asking that question is who defines protection and who does it serve? So my understanding historically of involuntary treatment, this idea of protection was actually to seclude and remove certain populations to not, quote, contaminate. It's literally the narratives that were used at the time, to not contaminate the rest of the population. So if from a historical perspective, who does that protection serve? I don't think it serves the individual, because at that time they were chained up. There was even apparently, like, what's it called? People would pay a fee to go walk around these asylums and for entertainment. So I think it's a very complex topic. I don't think that there's a clear delineation. I think that protection can serve a purpose, but it very much matters what the impact is. Right now it's about intent. Oh, I should protect this person because they're not capable of blank or whatever it is. But the impact of what our protection of our system currently is doing is actually harming people and traumatizing them. So there are manners in which we can actually, I think, better align human rights and protection in order to put the person first and central versus the system first and central. So currently the Mental Health Act, in terms of accountability processes, healthcare providers are pretty much not held accountable. They're not liable for their actions under the Act legally, rather the institution is. So I'm not sure if that really answers your question, but if you have more questions related to it that are more specific, I can totally answer them, or if anybody else has thoughts.
Yeah, and this is my last two slides that I didn't have time to get to. I'm sorry, I have too many things to say about this topic. But I think the idea that you've got, well, yeah, sure, there's human rights, but then there's also protection and treatment, and those being two different ideas is a false dichotomy. Like, exercising your human rights is really good for your health. And in fact, those two things are interdependent on each other. And taking someone's rights away is bad for them. Like it raises cortisol levels. There's even this like fascinating research about like constantly being exposed to or fearful of discrimination or incursions on your personal freedom. Gets into like epigenetic levels. There's like long-term impacts of racism or sexism or ableism, for example, is really bad for your health. And so on a micro level, I think the way we talk about this is, well, yeah, sure, there's the rights, but you got to take them away to treat healthcare. But in fact, I'm more interested in having a conversation about the idea that, you know, you're going to do harm to someone by taking their rights away from them. It creates trauma. It creates alienation from healthcare services. It creates avoidance of accessing services. So that does harm. And so the question is that harm going to be outweighed by the benefit of the clinical or therapeutic intervention? And that's where I think the conversation is more interesting, because exercising your rights is very good for you, and promoting transparency, promoting accountability, as I've touched on, you know, the right to be heard through these procedures is actually linked with improved therapeutic outcomes, improved healthcare outcomes. So I actually just wish we would stop having the conversation like it was a tension and start talking about it as like, how do we do healthcare plus human rights, and human rights in our healthcare and healthcare in our human rights, and moving forward together, because I don't think they're in opposition at all.
And to touch on that point, I think that the systems actually reinforce this narrative of opposition. Currently, the systems and structures in place for involuntary treatment treat protection as a kind of paternalistic approach and a very specific individualistic approach that has nothing to do necessarily with engagement of the patient. So it's kind of reinforced in a structural way as well. But it doesn't have to be, I agree.
Well, if I could just interject, one of the challenges with complex mental health questions is that for many people it's largely invisible to them. It's just sort of a theoretical thing that goes on somewhere in society, but I don't deal with it on an everyday basis. And yet I think that there's a sector of the public that increasingly gets disturbed by the encounters on the street of those who they perceive to have difficult, painful lives and feel that somehow society ought to be doing something for them. And what thoughts do you have about what we ought to be doing about that sort of general common misunderstanding or interpretation? I would guess many of those people would argue, if you put it to a vote, that we should be involuntarily detaining a lot more people.
Mm-hmm. Yeah, included the mayor of Nanaimo. Did you guys see that stuff?
Well, I don't think that there's necessarily one solution, but for me, while I was doing my research, I just noticed a dire lack of resources, right? We have a lack of psychiatrists in the community. We have a lack of coverage for therapy in the community. And if we don't treat smaller mental health issues in the community, then they escalate into crises where we have to apply the Mental Health Act. So we need more interventions that will allow us, more resources that will allow us to intervene earlier on to prevent using the coercive measures when you have crises. Because when somebody is interacting with the mental health system in crisis, it's almost impossible, I think, not to traumatize them in some way. And in terms of resourcing, I know of several facilities that will not treat voluntary patients. They are so resource strapped that they're only justified in treating the most serious cases. And they define that as being involuntary, right? So I know of people who have gone into these facilities asking for voluntary care. And they're told, well, you can stay, but only if you agree to be an involuntary patient. So what we're asking people to do is relinquish some of their human rights in order to access healthcare. And I know there's a broad spectrum of opinions about the Mental Health Act, but I think that no matter where you fall in that spectrum, that scenario, there's a problem with it. It's wrong, right?
Yeah. By the way, like my clients, they're smart. They figure this stuff out, and they know that the healthcare system takes that approach of like, well, if you want admission, you're probably not sick enough. But if you say you don't want admission, then we know better than you, and we know that you do actually need admission. And so I've had clients who tell me that sometimes they lie about that to get admitted, that they've clocked on, and so when they know they need admission, they'll go to ERs and say, I don't want to be here, just to trick healthcare providers into giving them the access to the voluntary services that they would have otherwise needed. Like, that's a very unhealthy structure that we've set up, that we have to be asserting that we know better than you in order for you to get the healthcare that you need. It's a very strange cultural place we've landed.
I think just to go back to your comment, Sally, though, about the people who are concerned about those who are, inadequately housed and visible to those of us who that comes back to a basic human rights question as well, in terms of people being provided with the basic needs that they deserve to be able to live. So beyond Mental Health Act, we need to be providing those types of things and interventions like Housing First, where we know that is a requirement for life before we even look at other things like treatment.
And to tack onto that, with the discourse analysis piece, looking at the history of the degradation of the social safety net since the 1980s, since the introduction of neoliberalism, our social safety nets have been degraded severely. And what we're seeing, for example, throughout communities, especially in the Downtown East side, is the impact of the reduction of social safety nets, I think.
And while obviously there are lots of advocates speaking out about that and taking action on that, there's lots more nursing can always be doing to join in that too. Because of what it sees firsthand, it has some credibility and trust in speaking that out. I want to make sure there's people who may be having a kind of contrary perspective or a different angle on something that this powerful group hasn't quite mentioned. I want to make sure everybody feels free to speak up, even if it isn't exactly the dominant view that's being expressed here, so that we can just get some dialogue.
Just wonderful job in demonstrating how much work we need to be doing on the Act. But two things that come up for me from a nursing perspective is that the students that are in clinical and introduced to mental health care in their actual psychiatric units and in the GA, St. Paul's and forensics and all over, oftentimes are very shouldn't say offended, but are really confused by some of the things they see. And so there is a lot of energy that gets put into that through my dialogue, the constructive dialogue, because they see what's going on. And a lot of times it's when someone is, in the quiet rooms, or they're seeing, some of the patients that get reprimanded by the nurses. So they're seeing some of the normal nursing care on the units and some of the everyday practice very confusing, and it saddens them. And so I think that from a nursing perspective, I think we need to actually start maybe from our perspective as nurses that practice in mental health, and how can we make some help with the practice changes. If we're not talking about real hospitals, up away from academia, we're looking at hospitals that have a lot of people coming and going, and that's where we're seeing bullying between from the nurses, we're seeing bullying the patients. So even that, and you can imagine if you're a involuntary patient being in that environment, how that affects. The other piece is that we're seeing acute care is oftentimes having maybe one mental health bed. And so the nurses oftentimes see, if we can get this patient maybe stay in, they'll get the care they need. That takes place in perinatal. It also takes place in acute medicine where someone really needs help from a physical point of view, but doesn't want to stay in the hospital. So there's those pieces that we can maybe work more.
So in case that wasn't
suggestions.
picked up, I just really brilliant examples of how confusing it may be for nursing students to witness what they're witnessing and also try and deal with the interpretations they're getting of why nurses are doing what they're doing and to whose benefit. And how to disrupt all of that is a significant challenge for clinical educators, bringing people in, facing that. So that's a good comment, great comment. Anybody want to pick up on it before we have more comments?
Well, I mean, I have a question for you guys, actually, because you know more about like your associations and bodies and representatives. So I routinely hear from nurses who say exactly what you just said, that actually, and a lot of what Emily touched on, that actually enacting this is contrary to what I think is ethical care, what I think is patient-centered care. It's sometimes quite traumatizing for them as well. And so can you tell me, like, why haven't nurses as a profession spoken up more about needing to change this? And like, what would that look like? Like associations or unions or?
I think part of it too is there's some nurses that go with that. Like I think, in our, I should say training, because in our, because I know that we try to really work on that piece, but I think that things, just practices, policies get put into place and people just get into this really rote mode when they're in practice. They might question, but their partner might say, well, he needs to be, or, there's all this small talk. So I think it's how we're actually approaching, how we educate and practice in general and policies at the ground.
We've got a complex environment in the moment in which we do have a union, the nurses union, which has had quite a large campaign portraying all patients in mental health world or otherwise as a source of danger to nurses. And I do think that there's a tremendous opportunity to take account of argument, and that can be done and will be done. I'm making notes quickly. So, and I think that there's much more that the professional association can do to communicate about this, because there's nothing I've heard to this point that would challenge that. And Maya's recently posted a blog, but we can see if we can move that into a position statement, for example. I'm looking at Emily and others. There are things we can do to start to move that forward. And of course, we can be informed by partners and allies that can help advise on some of the nuances of how and where and where to target those kinds of missions. So that's great.
I just follow up with that.
Yeah, and then I've got you next, and then you, Elizabeth. So
I just wanted to say that at risk of being really unpopular amongst my clinical colleagues, I think that many of these contexts, it remains an approach that they buy into and that they use for their own benefit. And this was part of the reason I couldn't practice there anymore. A really, I guess, poignant example for me was coming in one night to a shift or working a shift one day where, we had patients that were removed from seclusion because they didn't require it. The care was provided in the open kind of hallway space that we had access to. And colleagues came in the evening and wanted to focus on their Facebook account. And so, riled up clients to the point where, it was said that this was required for safety and, put into seclusion, doors locked, cardboard put over the window so that they couldn't be looking out. It is a very challenging context to work with. And when I left regular practice and would work casually, and when I would raise concerns, I was met with, you don't remember what it's like to be here. And so I think it is a very, in many ways, dysfunctional culture that needs some radical disruption, not just more of this talking about how there is injustice there.
Mm-hmm. Next point. You want to come up a little bit closer?
It's really, I'll just.
Okay.
Two very separate questions. To the other. I'm wondering if you could speak to the experience or the place of youth relative to the Mental Health Act, both broadly, and then I'm also curious, if you work with Form 13, if you can speak to youth and Form 13. So maybe the youth in general, mental health act, and then a chance youth and Form 13 and their ability to understand or the ability to communicate rights to you.
You can start off with a.
Sure. I mean, certainly, like, I used to work for Community Legal Assistance Society, and they represent youth, all the way, I think, down to like 11-year-olds, all the way up. And certainly the Mental Health Act delineates between 16 years old and under and over some, I think, drafting errors that have excluded some rights that apply to adults from the youth population. You're nodding like you know exactly what I'm talking about. Yeah, and so certainly, like, we had certain principles at class. So because it's legal aid funded, unsurprisingly, there were huge shortages, and sometimes we would have to deny people representation who qualified. But we always had a policy that any youth automatically got representation. They bumped to the top of the line. We did our best to look at the UN Convention on the Rights of the Child. We talked with the Mental Health Review Board about making the hearings child-centered. And what changes and accommodations could be put in place in those hearings. But certainly, like, I think this is public, that the representative for children and youth is doing an investigation currently into specifically how the Mental Health Act is applied to children and youth, which will be coming out very shortly. So I think that will elucidate the topic a little further. Was there something more specific that I can
I guess sort of the idea, so the mental health exists, like our Mental Health Act exists, and then how does it need to just be completely gutted to be better for youth? Or can it be tweaked? Because my sense is that maybe the history of it, my sense from reading is that it's really like youth come into it, but it was written for adults and with adults in mind. I don't know if that's an incorrect read, but if you could speak to the ways in which maybe the Mental Health Act is particularly not serving youth, or if that's an issue that comes up.
Yeah, I mean, I think the Mental Health Act needs to be gutted for everybody. I don't think it's working for clinicians. I don't think it's working for patients. I don't think it's working for anyone. I think, you know, in particular, if you look at the demographic breakdown of detention, youth girls is the highest rising category. So I think more and more, we're seeing the Mental Health Act being used with young girls in particular. I think that's problematic, and we could probably talk about why. There's some sexism at play there. There's some paternalism at play there. But it's hard to generalize, because the other population that is really hard hit by our Mental Health Act is racialized people and Indigenous people. There's documentation that Indigenous folks in particular receive higher levels of coercion, more likely to be subject to restraints, more likely to be subject to seclusion than their white counterparts. So it's hard for me to point to a population and say those are the most harmed by our Mental Health Act. I think there are ways in which youth are uniquely harmed, but I think the Mental Health Act is doing a disservice to everybody and absolutely does need to be gutted from the top.
By gutted, you mean what?
Like overhauled. Like, let's just look at it.
Yes,
you know, so most provinces, they have this built-in safety where they review the legislation every 5 years. You know, as Maya broke down so well, we haven't really substantively looked at our Mental Health Act since the 1960s. Why can't we review it? There's been huge advances in evidence-based best practices. There's been huge advances in human rights instruments since that time. Let's just look at the act and improve it to make sure that it is informing, you know, that we can make sure that we're giving as dignified care as possible, that human rights are promoted as much as possible. You know, there are jurisdictions that say they have completely eliminated seclusion and restraints from their psychiatric boards. Why aren't we? Why isn't that our goal right now, to completely eliminate it? Why are we still using it? Why are we doubling down on it? Why can't we be doing better?
Anybody else want to jump in on that before we go to another question?
I think I'm Form 13.
Yeah, well, on Form 13, I only tested with adults, so I can only speak to their comprehension. But if adults, so I ran the forms through the Flesch-Kincaid reading level checker, which is a useful tool, but should not be relied upon to show that something is plain language or not plain language. But it is at, I don't remember exactly, it's on like the grade 13, grade 14 level. So for the general population, health information, we're encouraged to knock that down to grade 6 to grade 8 reading level for comprehension. So the fact that it is difficult for adults to understand, it's probably also difficult for youth to understand. Now, there's Form 13, which is for really for the adult population 16 and over, and Form 14, which is for children who are hospitalized under the Mental Health Act on authority of a parent or guardian. And that is the form, as Laura kind of hinted at, that has what we think is probably a drafting error. I mentioned that people who are certified have the right to request a second medical opinion to review their treatment, their treatment plan, but that right doesn't appear on Form 13 at all. And Tristan Waite, she did her PhD on looking at Form 14 and found that, yeah, there is this disconnect between what the Act says. The Act sort of implies that everybody should have the right to a second medical opinion, but that's not actually conveyed to youth who are given Form 14. I don't know if that answers your question.
Yeah, I mean, I think that's, you could talk for hours about it.
Yeah.
Can I just respond to what you put out there, Laura, which was that many jurisdictions have been able to effectively get rid of seclusion and restraint. Why don't we? I think it's a complicated question, but I think that there's two issues that I would highlight. One is that it would require healthcare providers to get out from behind the desk and actually provide care. And I think that what the research tells us is that many people who work in these settings don't feel they have the level of training that they actually need to provide competent care and to go beyond a surface level type of interaction with people and to know how to engage beyond a biomedical model of treatment that relies on the provision of psychopharmaceuticals and other forms of biological treatment like ECT, for example, and to engage in a therapeutic relationship.
You're up next.
Yeah, and thank you all so much for the work that you're doing. It's so inspiring. Perhaps just for a bit of context, my name is Elizabeth. I, along with Emily, teach in the undergraduate program here and have taught the mental health course for our undergraduate nursing students. But my background, I come from the United States and I'm a psychiatric and mental health nurse practitioner from the US, which is a sort of scope of practice and particular advanced practice role that doesn't exist here in BC yet. So my perspective is a little different, and I'm learning the nuances of British Columbia's mental health care system, mental health act. I was really curious to get some thoughts from the panel about this question of why. Like, why isn't nursing doing more when we know that both nurses and nursing students experience tremendous moral distress around practicing in these contexts? And, we start the mental health class by having our students read the great article by Ali Slemon, kind of looking at moral distress in nursing students who are doing their practice experience in psychiatric nursing environments. But my thought on this is that there's a lot of challenging power dynamics within nursing and within nursing education itself. And we sort of put students in positions on units, and because we need to have them have access to these clinical experiences, but often we know that they're going to go into units which will cause them moral distress. And they're afraid, and the outcome of that educational experience is reliant in some ways on the judgment of a preceptor or a more experienced nurse who may be part of that system. And so I think they articulate very poignantly the challenges of working within that power dynamic and feel quite powerless to challenge that. And sometimes I think we reinforce that messaging. You need to get through this educational experience and then you can start to make the change. But during that experience, I think trauma happens, and I think habituation to that environment happens. And we might also have people pulled away from psychiatric or mental health nursing because of those experiences who are otherwise quite passionate about this. So I guess my question, I appreciate, Emily, you landing on hope, is any suggestions you might have about us coming from an educational perspective, like how do we start to disrupt this in a meaningful way? And Sally, I look at you also, like as part of that. I know you're not a panelist, but I wonder about your thoughts on that. Like, how can we really start to make that shift when we know that our students are in a position of relative powerlessness in a lot of these environments.
I think I could just empathize with that experience. I know in my undergrad in psychiatric nursing, I would just simply ask questions like, oh, you know, I saw this experience of this person being secluded in this manner. That's concerning for me. Like, what are your thoughts of the clinical instructor? And over time, I just got labeled as defiant and not actually wanting to be a psych nurse. So within institutions themselves and nursing them itself, we actually reinforce a form of practice. I understand with UBC that it's quite critically reflexive and reflective as well. So my experience here has been very different. There's a lot of facilitation of critical thinking and ideas. So I think just even opening that door and allowing for critical thinking within practice is so important, because my experience was not necessarily that, and it was not encouraged. So that's one thing that I would say, is just keeping that door open for conversation, because apparently being critical is the same as critiquing and being negative, which is very much not the case.
I think it helps to pick critical instructors and make sure there's really good dialogue with confidence, and that we're always talking about it, and then letting Elizabeth know in theory what has come up over the week. So I think keeping that dialogue open and hearing what they're going through is important. Sorry.
We also have a sort of another semi-invisible structural barrier with the two historic colleges and two kinds of nursing that up until very recently have not been able to find a structural way to come together on shared initiatives. Not that people can't necessarily work together, but there are culturally embedded things that are problematic. And when two groups are more inclined to blame one another and to not have the conversation, I think that creates a difficulty. We can capitalize on the fact that we are now within the same regulatory college, so we don't need to battle about who's who in the zoo, and we can come together in a professional association which has the potential to be a policy voice. And I think this is the notes are taken. This is the place in which we can move together, not in the blaming one another or which designation is the problem kind of question, but what do we collectively, we all come with these kinds of ethical codes and these kinds of ideas about equity and these kinds of ideas about human rights. They're pretty embedded in the DNA of what nursing is supposed to be about. And there's no reason that we can't assert them more loudly and strongly with partners and get more actively involved collectively. So we're perhaps at a time when we could do that we couldn't do that before.
I've called for radical disruption, and I don't know what that means in this context, but I'm wondering about drawing more heavily on on human rights, and bringing that to bear on these, within these unit cultures, and because it doesn't stack up, right? So there's violations of that happening every day, and maybe there's some kind of strategy to kind of halt that in a way that hasn't been done before. I'm not sure, but through status quo, nothing's going to change.
Annalise, you were long waiting, and
oh, I can wait. I don't mind, as long as I get a.
You're next on the list. Just want you to know that.
And just quickly to point out, I think that this is all just history showing itself currently. Historically, the way that nursing has functioned in psychiatric settings has been problematic, has been colonial, has been ableist. So pulling that forward and seeing what narratives continue to act today, and being able to be critically reflexive and be like, how does this not serve the system currently, even though historically it was very deeply embedded in day-to-day practice. So it's very complex.
I have ideas in response to that, but I'm happy to wait if we're shifting gears. So I have many ideas. One is just a basic, knowledge is power. And so when you're talking about undergrad mental health nursing course, I assume you teach the Mental Health Act content in that?
Yes, we were lucky enough to have Iva come in and speak with us.
Well, and part of this is, I think, law and healthcare hasn't been good at talking to each other and partnering with each other, right? And similarly, much like I would never teach a healthcare topic, I'm not qualified, it really sort of baffles me why health teaches legal topics without having legal educators involved, right? So why are, first of all, why are nurses being asked to give legal rights notification under this Charter of Rights and Freedoms? You have to explain what habeas corpus is, which, by the way, is an ancient prerogative writ that was abrogated through the statutory amendment preserved through Section 10C of the Charter. And if you don't understand what I just said, it's because I have a legal education and you don't. And I don't think it's appropriate to be like excluding or shoving out the legal profession from healthcare settings. And I think raises one of those questions around like, you know, that Shakespeare quote of like, the first thing you do to prop up tyranny is kill all the lawyers. And I think in BC, we've got a really great example. We're one of the only places in Canada where there isn't independent legal rights advice delivered to detainees. And that creates a huge amount of downstream effects, I think, at all these different junctures. And so, I would invite you, if you're teaching students, to ask a lawyer to teach a law topic, to ask a law professor to teach a law topic. And I'm super happy to like be a guest lecturer or like do a workshop. And I have done workshops at St. Paul's, at Grand Rounds, and it's primarily on the themes of like, why do the human rights matter? So that when students encounter in clinical practice, resistance on wards or disturbing practices, it's going to be so hard given all the power structures and dynamics to speak up. But to the extent that they can have a little bit of knowledge under their belt to say, well, hang on, I think this is why XYZ matters, I think you're arming them a little bit more. And then my other suggestion is speaking up from the platforms that you have can really help students. So law is also a very entrenched profession that needs a lot of progress, and I really struggled in law school as well. Might have been labeled defiant a few times. But what really helped me was seeing professors who would like publish an op-ed that was a little bit contrary to dominant thinking, or speak up or support a campaign that I found contrary to the dominant discourses going on in that law school. And so, I would invite you to think about the ways that you can speak up, either through associations or even just as individuals, to model something different for students.
Thank you. I think that invitation was loudly heard.
So thank all four of you. And I was having trouble with your names, but I think I got Laura. Okay, so you had some really good.
Your voice is quite quiet. So look at it closer. Thanks.
Some things that I noticed. I was very surprised to hear that in our province, we have variations between the various areas. There's 7 areas, correct? Help me know with the right word. Healthcare. That really, really surprised me that it wasn't uniform in our whole province. That was good information to receive today. And when you talked about when you need the legal people to come in, and at 6 days they were already canceled out because with today's medications, patients respond more quickly. So they can look really sick on day 1, minute 1. And if they get the right treatment, they improve that quickly. Yep. So that's what would have happened, which is it's hard to get those meetings pulled together, have the right people there. And so by day 6, yeah, they could be better already and have it canceled. So I wouldn't worry so much about that myself, unless you have some other reasons.
Oh, I don't understand what you're saying. So the patients who were decertified prior to their review panel?
Yeah.
Yeah, no, I'm not worried about that.
You're not worried.
I'm worried about the population that remains certified and doesn't ask for a review panel. Yeah.
Great. And then over time, I started my career in psychiatry straight out of high school, age 17, Riverview, 3,000 patients in that place at that time. And I couldn't stay there because the provincial government was already saying they were going to close it. Well, why would a young person stay in a place where you're going to lose your job? On I went on to get more training at St. Paul's, where you're at. So thank you for that insight into the variation in the province. Was anybody else surprised by that? Or just me? No? Okay. And also, in that time, diagnoses have really changed. Like when I was a student nurse, there were about 2 diagnoses. You were schizophrenic or you were neurotic, and there was no in-betweens. And if you were psychotic, you were automatically thought to be schizophrenic. Whereas since that time, we have learned psychosis shows up in all kinds of illnesses and all kinds of reasons, like drugs and stuff like that. So that makes a big difference too. I was interested in the average, I want to move to you, average length of stay. Were you able to get any averages for you said there were 20,000, I think, that had been, and did you do it, were you able to get any facts on what was the average length of stay for these 20,000 people?
It depends on the institution.
I'm going to need to ask both of you to speak up.
Yeah. Oh, sorry. So it depends on the institution. So we're talking about length of stay for approximately 20,000 people that are admitted voluntarily under the Mental Health Act annually. And the length of stay varies. It depends on which unit you are actually in. It also matters where in the province you are, whether it's more remote or not. So I can't speak to provincially, but I can speak to, for example, I know at St. Paul's in the APSU, which is downstairs Porridge, approximately try not to keep people more than 48 hours, but that's to transfer them to a mental health area. And usually that's like 7 to 10 days approximately, but that also can shift. Yeah.
According to the Ombudsperson's report, the average length of stay was 14 days.
That's pretty good when you think about it. I mean, I remember people being committed for half a year.
Oh, yeah. And it's, just to be clear, an average is that, yeah, like there are people who have been detained for like 20 odd years still in this province. But that's an average because some are released like within 2 or 3, 48 hours type things.
And then in talking about what the nurse said about, you know, I can get you in if you do this and that, the way I read it is the nurse cares. She wants to do something, but there's nothing that she can give. So she says something that ends up being, you know, thinking the way to approach it is to do it like this. You have to sneak in, I can lie, I can do this, I can do that. And it's really hard under that situation because when I started nursing, we had a much better ratio of nurses to patients. We had about 6 nurses on a unit of 20, 24. Then you still had a head nurse, which these are all disappeared kind of things. Whereas now they have 20 beds and they have 3 nurses. And that's not enough. And the union will say, okay, they get an extra $3 if there's a shortage of nurses. Doesn't help them at all. So the coverage is so much lower than it used to be. So that was another thing I wanted to add in.
You've seen a lot of changes over that time, haven't you?
Yeah. So the DSM has changed a lot. When we first started, few diagnoses. I think we're up to number 6 or 7 now. Anybody can bring me up to date? We're at 5, okay. So now, so many more diagnoses. It almost puzzles me when some of the new ones, because I think they could be grouped better. So those are, and I'm glad this is happening, and maybe we can do something as a group. Oh, and one last thing, it would be great to have law students come to the hospital and spend a couple of weeks, just have that experience of seeing what it's like.
Oh, yeah, we do.
You do? Okay,
yeah,
that's good.
There's clinical internship programs that go through all the psych wards. Yeah.
Okay, thanks.
Yeah.
All right, you've been waiting patiently.
Hi, I was wondering about what you were saying before about changing the care in hospitals and for students especially. And I definitely know for us, because it is morally traumatic when you go in and you've been told something one way and you get in and it's very different. You don't like know how to, well, first of all, you just do what your clinical instructors tell you to do. And more often just what the other nurses on the unit tell you to do. So for us, I definitely think it would be really beneficial to get this kind of information like very early in our program, because you start seeing mental health issues like day one. And I know for us, our mental health rotation isn't until our last rotation in school. And I don't know why hopefully they come today, but like we don't really get to talk about this stuff, and maybe it could be in ethics or something, because we don't even know how to make like critical thoughts on our own in a clinical setting for a long time, even though, and so you learn all the wrong ways first, and then you're gonna have to go back and relearn the other ways after, which is challenging, definitely provides more of the stress.
I really appreciate you raising that, what it feels like from a student perspective. And I suspect all my colleagues who are involved in the education end of it would really welcome continuing to think about what it is that a school like UBC could be doing better and differently in the preparation, in the support during, in the, work with whoever the preceptors are that are going to be connecting. All of that, I think, is clearly an ongoing process. And I don't think input, well, if there's ever a point which we say we've had enough input, thank you.
I just had one more question too. So we talked about how many problems there are with the Mental Health Act, and I was just wondering, like, who is it serving and who is putting up resistance behind changing it if it sounds like everyone who knows what they're doing doesn't support it?
Good question. Where's the resistance coming from? I feel like I've got the most qualified answer.
Well, I don't know if I'm in a lot of trouble. Well, first of all, I think that the Act as it's currently structured does give physicians a lot of power. So I'll just put that out there. They are the ones who make the certification decisions. And so, you know, anytime you have a power hierarchy or difference, the person in power is less likely to want changes that would disrupt that power, right? And so I don't get into further trouble. I think that's where I'll leave it. But there are also some, I think in this province, if you are even remotely critical of the Mental Health Act and say that it can be better in certain ways, there are certain groups with particular interests who will accuse you of being anti-psychiatry, who will accuse you of wanting to completely abolish involuntary care and treatment. And I just want to make it very clear that I'm not going to speak for anybody else on this panel, but for me personally, all I'm advocating for at this moment is a harm reduction approach to applying the Mental Health Act. Okay, we have this law that we have to live with. How do we implement it in the least worst way possible? Because right now what we're doing is leaving people feeling dehumanized, traumatized, disengaged with not just the mental health system, but the health system more generally, which will have an effect on their access to healthcare.
So in my conversations with ministers in government about this, I actually think we missed a really great opportunity with this ombudsperson's audit and the compliance efforts that are being made now. So basically the ombudsperson looked at all this and said, healthcare providers aren't complying with the law. And I think that's a really unfortunate place to end that conversation. The Ministry of Health is now investing a huge amount of resources in doubling down and complying with that law. And I have told the Ombudsperson's office this, I've told the government this. Did you ask healthcare providers why they're not following the law? Because they're not evil. Like very, very, very few people go into healthcare to create harm or with that intentions, right? Everyone's trying to help. And if they're not following the law, it's probably because this law is really bad, right? Like the forms are hard for patients to read, but the forms are hard for healthcare providers to fill out. It's really hard to know as a nurse how you're supposed to complete a Form 5. It's really hard to know as a physician how you're supposed to complete a Form 6, right? So rather than doubling down on a law that isn't working for anyone, could you actually just change this law? And the answer that I get is you're really the only one who wants it to change. And I've been a vocal critic of the Mental Health Act for a long time and asking for a review and amendments. But I think government is only hearing from like legal advocacy organizations. And essentially what they said to me is, Mental Health Act reform is going to be high controversy, low reward politically. So I think what we need to do is show government that it is not just legal advocacy organizations that want this change, that it is healthcare. By the way, our current government would be exceptionally interested in knowing that a labor organizing body like nursing wants the Mental Health Act looked at, right? So government has basically said to me, I need to hear from more people than just you. If you're stumped on how to do that, please come chat with me afterwards because I have lots of concrete ideas about stuff we can do together. But government needs to hear from people that they want it to change, and I don't think they're getting that message.
Patients could feel the pressure on it.
Yes, and some do speak out. I also think, Mental Health Act patients are some of the most marginalized sectors in our province, and they're struggling with poverty and homelessness and discrimination, and it's a lot to ask them.
Yeah.
Yes. Well, and it may be possible, with looking around the voices in this room and others that you've referred to, Damon and Ken being very active as well, to try and see if we can encourage the professional association to take a more overt view. And I can imagine any kind of position statement would want to get the details right, so we may have to consult on you, but it should come from the voice of a nurse. So I'm not sure who we'll point to, but a group needs to work on it, but we need to start off with a voice and then see if we can move it into more a collective voice. Meg's already done a bit, so we can't tap her. And Emily's done a bit too, so we'll need to figure out where's the appropriate place for that to come from.
I want to go back to the issue of resources though, because I think that a lot of the problems that we're seeing comes from the fact that in the moment of crisis, there is an expedient way, and then there is a way that might produce better long-term outcomes that's more patient-centered, but that's harder and more costly and time-consuming to implement, right? So is it more expedient in a particular moment to put somebody in seclusion or to de-escalate? Is it more expedient in the moment to inject somebody forcibly with antipsychotics or to negotiate with them to accept treatment voluntarily? Is it more expedient to sit down with them with their health records and explain their treatment plan to them, or is it more expedient to simply impose a treatment plan? So there are all of these moments, these points in the course of care where you can take the expedient way, or you can invest in a more long-term therapeutic relationship. But I recognize that long-term therapeutic relationship takes time, it takes effort, it takes training, it takes money, and that if you've got 2 or 3 patients waiting for care, that's often not an option.
It sounds like a lens, though, the nursing could very, very easily collectively get behind, because there isn't a nurse in the province that wouldn't understand that incredible pressure for expedience on all matters, which is always in tension with that ideal of patient-centered care and, individual human rights and that kind of thing. So I think it could be a really useful way in. Harm reduction is also, it's not particularly controversial at all within nursing. So those ideas that are deeply embedded into friendly topics and conversations nurses are familiar with might be a useful way to push the conversation.
I think I would also speak to the reason why it's not being looked at is because I see it as also systemic ableism.
Yeah.
So who do we value and why? Which laws do we revisit and why? Yeah. So yeah, I think that's a huge contributing factor. Also in terms of financially, I think it's between 4 and 7% of the entire budget of healthcare goes towards mental health entirety. So in terms of value systems, where do we place funding and why is also quite
and speaking of parity between the resourcing for physical health care and mental health care.
What is the percentage in other provinces? Is it lower, higher?
Great question.
I'm not sure.
Not sure. It's something that might find out.
Yeah. Lots of things to pursue. I'm going to give the panelists each a moment to have a final comment, unless there's any burning question. Looking around, I haven't seen any other hands waving enthusiastically. So, maybe perhaps when we sort of formally close, they might answer individual questions. Did you have one more?
I might be too granular, because I think there's been some really lovely, it's been kind of moving broader and broader in the conversation. Maybe afterwards, I would love to talk more about the words physical deterioration as it relates to the Mental Health Act. But maybe that's too granular for the trend. Those are very interesting words.
A very important question, but the Healthcare Consent Act versus the Mental Health Act constantly, yeah.
And when something stops being Mental Health Act and it starts being, and the boundary, and maybe that's the content.
Well, Laura, Maya, and Emily, last comments. We've got 5 minutes for your parting words, if there's any final things that you want to make sure we've said.
I didn't prepare a closing
statement.
I can go first. I just feel very appreciative to be on this panel with such strong individuals and a really strong knowledge base. And it's really nice to see that there has been an increase in terms of interest regarding mental health and a normalization of mental health issues, because it does affect everybody at some point of our lives, if not directly family or with ourselves. So for me, I'm just super proud to be in this moment, these amazing people, and appreciative of having you on here too. And great questions too.
I'll just say that I've appreciated the opportunity to dialogue about this and perhaps leave even a little bit more hopeful than I was at the end of my talk, and see opportunities to collaborate with some folks in the room and to bring in external expertise into a nursing discussion around how, as a nursing community, we might be able to push this forward.
Yeah, I appreciate why we talk about harm reduction. There's a lot of harm, a lot of space to reduce it. But I'm still operating from a place of more substantive hope than that. I think we could be doing a lot better in BC, and I think we can. Like, I'm just starting a 3-year project to overhaul the Mental Health Act. I hope you guys will partner with me on that. I think we could be doing way better for patients, way better for our province. And so I'm still in this place of like, let's just look at starting from scratch. What would a good functioning Mental Health Act look like? And then hopefully that can trickle down into these systems.
We could get copies from the other provinces.
That's not a bad place to start.
I guess I will just close by really reiterating my appreciation for the patient-oriented research team that I worked with to produce these rights materials. And they're in use in a few health authorities right now. And you can find these materials on our website. We also have these materials translated. So in addition to the work that I did in my in my dissertation, I also did clinician focus groups. So I went into 5 different hospitals and spoke with nurses and social workers, occupational therapists, people who do rights advice, to find out from them, what do you think are the main barriers and main facilitators to giving rights information to involuntary patients? And one of the things that kept coming up over and over again is that we are in BC, one of the most diverse places in the world, and Form 13 has never been translated into other languages. So that was such a gap that I used some of my research funding to translate these materials into 8 languages other than English. So they're all available on the website. Please use them.
Thank you. Yeah. So there are copies there for people to look at if they haven't seen them. And there is still food at the back for anybody who is starving and hasn't had a chance to eat. I just want to express my thanks to all of you here in the room, the people who have been on the other end of the line or who will be, because all this conversation will be recorded and available for whatever use. And I especially want to thank all of the panelists, all of whom said yes in a nanosecond when I put out the ask to see if they would be willing to talk. They're clearly committed, and I hope those of you who aren't already part of the School of Nursing will consider yourself future allies and partners, because we've got a team of people here that I'm very sure can be helpful and engaged with the kinds of things you're interested in.
Can I just pose one more question? I was so engrossed in the conversation I missed one of our online questions, so I would hate to leave them hanging. This is from Jess, who asked, we work in a system that's so focused on safety, but there does not seem to be a clear definition of what exactly this means. It's used to justify detaining individuals, removing rights of privacy or independence. I'm wondering if the panelists see this risk-averse system playing a role in these issues.
Yes. Yes. I heard yes. And that sort of risk lens sounds like it's one that nursing could actually have a go at, and I don't know. It just seems to me that there are nursing voices in the public space that are fueling that, and that perhaps we can have some thought about what we can do constructively in that regard.
A quick kind of side random thought that came up regarding that question was, I feel like there's a lot of discourse regarding how people interact, which is very important. But looking at how the environments of psychiatry are actually structured, like the units themselves do not promote harm reduction or risk reduction necessarily. In fact, it can be quite activating and traumatizing for many, many people. One comment I found really interesting when I was going to St. Paul's was that, like, what do you see as St. Paul's as it's structured currently? I'm like, I'm not sure. It looks like a hospital. But like, this is actually reminiscent of a residential school and what they used to look like. So looking at structure and the impact of an environment and the way it comes off and its experience is very important, I think, in relation to that as well.
So bottom line is there's a huge amount of work to be done. I think you've got a room full of people that seem to, whether they've spoken about it or not, that seem to want to be part of the solution. So I'm hoping we can capture this conversation, and maybe there'll be many more. But I just want to really extend my thanks to all of you for your wisdom and your insight and the work you're doing, and cheer you on. And thank you all for being here.